In 1789, James Madison had a problem. After living for 10 years under the Articles of Confederation, Madison had worked tirelessly behind the scenes to bring about a constitution to devise a convention to devise a new constitution. In September of 1786, he participated in a preliminary convention in Annapolis. By 1787, he had secured enough support of key players like George Washington and Ben Franklin to convene a constitutional convention in Philadelphia. Now, the pressure was on the 36-year-old Madison. Before journeying to Philadelphia, he crammed for the gathering, like a student for his exams, from a chest full of books that had been supplied to him by his friend and mentor, Thomas Jefferson. For the cerebral Madison had a truly fundamental problem to solve. Like many others, he had concluded that the American regime, governed by the Articles of Confederation, was grossly inadequate and contrary to what the Virginia Declaration of Rights referred to as the common benefit, protection, and security of the people. But why was this happening? Why had the republicanism of the founding generation failed them so? For the previous 13 years, the people of the United States had been governed by 13 separate entities. State governments under the Articles of Confederation were thought to be Republican. The founders had thrown off rule by the aristocratic few in favor of rule by the democratic many. Under aristocracy, if the many are screwed by the few, the Democratic or Republican alternative was premised on the belief that the people wouldn't screw themselves. This is Cook County. This is how we talk in Cook County. But this Republican theory, the people wouldn't screw themselves, had unexpectedly proven to be false. State legislatures had begun enacting debtor relief laws that both undermined the rights of creditors and impaired economic prosperity, which required a credit market that can safely rely on the obligation of private contracts to collect from debtors. States also erected a debilitating assortment of trade barriers to protect their own businesses from competing firms in neighboring states. The result was a national economic downturn, a really Great Depression. So Republican government, as it was then conceived, was clearly not working for the common benefit, protection, and security of the people. But why not? Now, to answer this question, in April of 1787, largely for his own benefit, Madison composed an essay that's called The Vices of the Political System of the United States. But it was not an essay for publication. It was an essay for his own benefit. It was like a working paper for him to figure out what the game plan needed to be for the upcoming Constitutional Convention in Philadelphia. And so we have this document. It's a remarkable document because it shows how he was sorting through this problem. What was the problem? In Vices, Madison identified the source of the problem in what he called the injustice of the laws of the state. So first of all, the problem was that the laws the states were passing were unjust. The causes of this evil, he contended, could be traced to the representative bodies in the states, and ultimately, he said, to the people themselves. This, he wrote, called into question, quote, the fundamental principle of Republican government, that the majority who rule in such governments are the safest guardians both of the public good and of private rights. Madison concluded that we must be far more realistic about popular majorities. All civilized societies, he explains, quote, are divided into different interests and factions as they happen to be creditors or debtors, rich or poor, husbandmen, merchants or manufacturers, members of different religious sects, followers of different political leaders, inhabitants of different districts, owners of different kinds of property, etc. In a democracy, the debtors outnumber the creditors and the poor outnumber the rich. The larger group can simply outvote the smaller one. The majority, however composed, he continued, quoting him, ultimately give the law. Whenever, therefore, an apparent interest or common passion unites a majority, what is to restrain them from unjust violations of the rights and interests of the minority or of individuals? To illustrate this problem, Madison posed the following thought experiment, quote, place three individuals in a situation where the interest of each depends on the voice of the others, and give two of them an interest opposed to the rights of the third? Will the latter be secure? The prudence of every man would shun the danger, he said. Likewise, he asked, will 2,000 in a like situation be less likely to encroach upon the rights of the 1,000? In short, under the democratic version of republicanism of the day, there is nothing stopping a majority of the polity from engaging in self-dealing at the expense of the minority. Now, Madison concluded that what was needed was nothing less than a new Republican form of government that would address the weakness of democratic state governments while preserving popular sovereignty. As Madison put it, quote, to secure the public good and private rights against the danger of such a faction, and at the same time preserve the spirit and form of popular government, is then the great object of to which our inquiries are directed. Now, Madison was not alone in locating the ills facing the nation in the majoritarian democracies of the states. At the Philadelphia Convention, Edmund Randolph, our first Attorney General of the United States, observed that, quote, the general object of the convention was to provide a cure for the evils under which the U.S. labored. And he said, in quote, in tracing these evils to their origin, every man had found it in the turbulence and follies of democracy. Elbridge Gerry from Massachusetts stated, quote, the evils we experienced flow from the excess of democracy. Roger Sherman of Connecticut contended that the people, quote, immediately should have as little to do as may be about the government. Gouverneur Morris from Pennsylvania noted that every man of observation had seen in the democratic branches of state legislatures precipitation, in Congress changeableness, in every department excesses against personal liberty, private property, and personal safety. Even those who had remained more amenable to democracy, like George Mason of Virginia, admitted that, quote, we had been too democratic, unquote, in forming state governments. At the conclusion of the Philadelphia Convention, anxious citizens gathered outside Independence Hall to learn just what had been produced behind closed doors. The convention had been governed entirely in secret. It is said that, as Benjamin Franklin left the building, a woman in the crowd called out to him, well, doctor, what have we got? A republic or a monarchy? And Franklin is said to have responded, a republic, madam, if you can keep it. But while the new form of government devised in Philadelphia was not a monarchy, neither was it democratic. Yet Franklin still called it a republic. That's because the meaning of that term, republic or republican, had just been changed by the men inside the building from which Franklin was leaving. A Republican Constitution was no longer a democratic constitution, if it ever truly had been. In my book, Our Republican Constitution, I explain how these two fundamentally divergent views of the Constitution divide us even today. I call these divergent views the Democratic Constitution and the Republican Constitution, but I don't intend these labels to be partisan. There are political conservatives who hew to some aspect of the Democratic Constitution, and some progressives who adopt aspects of the Republican one. Many people, perhaps most people, flit between conceptions, depending on which happens to conform to the results they like on a particular issue. I contend that what divides those who adhere to a Democratic Constitution from those who favor a Republican Constitution are two fundamentally inconsistent visions of we the people, the first three words of the Constitution, that lead to two radically different conceptions of popular sovereignty. Those who adhere to a Democratic Constitution hold a different conception of we the people and popular sovereignty than those who adhere to a Republican one. A Democratic Constitution views we the people as a group. We the people as a group. And the purpose of a constitution is to empower the majority of the people to rule. The idea of we the people as a group is the people must rule. We the people must rule as a group, and the only way the people can rule as a group is for a majority to rule. How else are they going to do it? And therefore, the purpose of the Constitution is to set up a democratic mechanism to express the will of the people. It makes perfect sense. In this scheme, unelected judges are problematic because they are thought to thwart the will of the people as reflected in their legislatures. Under a democratic constitution, therefore, the will of the majority should generally prevail. In contrast, a Republican constitution views we the people as individuals. As the Declaration of Independence affirmed, we the people are endowed with certain inalienable rights, among which are the individual rights to life, liberty, and the pursuit of happiness. Then the next sentence of the Declaration, and I spend chapter 1 entirely on the Declaration of Independence, the next sentence of the Declaration says that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Not all powers, not unlimited powers, but their just powers are what they derive from the consent of the governed. But the purpose of government is to secure the individual rights that the previous sentence had just referred to, the rights to life, liberty, and the pursuit of happiness. So in short, under the Republican Constitution, first come rights, and then comes governments to secure the pre-existing rights of we the people as individuals. And then, to ensure that government is held to its just powers, the Constitution is put in writing, such as this, to provide the law that governs those who govern us. We are all governed by laws that are made by governmental agencies, but this is the law that governs those who govern us. Now, as I explained in several chapters of our Republican Constitution, the Constitution secures these rights primarily in two ways. First, by means of federalism, in which the federal government is limited to its enumerated powers, while allowing 50 states to adopt a diversity of social and economic regulations. And second, by a separation of powers in which the national powers to make, execute, and enforce the laws are placed in separate hands. But in addition, judges too are servants of the people, and they have a duty to keep legislators within what the Declaration calls their just powers by invalidating irrational and arbitrary laws. After all, we the people cannot be presumed to have consented to delegate to our servants in the legislature the power to arbitrarily or irrationally restrict the exercise of our pre-existing rights to life, liberty, and the pursuit of happiness. The death of Justice Antonin Scalia, combined with Senate Republicans' refusal to consent to any nominee until after November, has raised the stakes on an issue that should always be at the forefront of any presidential campaign, but usually isn't. And that is the future of the Supreme Court and our Constitution. As a result of his death, selecting the next justice is already a prime topic of the ongoing presidential contest. But now is the time to be clear about the nature of the choice we face. Most today assume that the current divide on the court is political, in the sense that the left side favors progressive outcomes while the right side favors conservative ones. But that's not truly the case. For example, when I argued the case of Gonzalez versus Raich before the Supreme Court in 2004, one might have supposed that the left side of the court would have favored my clients who sought to use medical marijuana as authorized by California law, while the right side of the court would have voted against so liberal a drug policy. Yet, Chief Justice Rehnquist and Justices Thomas and O'Connor sided with us, while the four most progressive justices stood in opposition. And then we lost 6-3 when Justices Scalia and Kennedy joined the ranks of the progressives. What was at stake for both sides, however, was not a policy dispute over marijuana, but a difference over constitutional principle. In particular, a principled disagreement over the sort of constitution we have and the proper role of judges in enforcing it. Do we have a democratic constitution in which the rule of the majority takes priority unless expressly prohibited? If so, judges should generally defer to the will of we the people as expressed by their representatives. Or do we have a Republican Constitution in which the rights of we the people take priority over the decisions of their servants in the legislature? And if so, judges have a duty to ensure that the servants of we the people remain within the constitutional limits on their powers. In Raich, the liberal justices put their principled commitment to majoritarian rule at the national level above their compassion for the sick, the suffering, and the dying. Kind of have to admire them for that. Conversely, the three conservative dissenters put their principled commitment to constitutionally limited federal power above their abhorrence of drugs. Now, we cannot be sure why Justice Kennedy joined the liberals, but Justice Scalia made his reasons clear in his separate concurring opinion in Raich. Under the necessary and proper clause, he wrote, the court must defer to Congress's judgment that it was essential to reach homegrown and consumed marijuana to enforce its ban on the interstate trade. In this way, did Justice Scalia adhere to the central tenet of the Democratic Constitution: judges should defer to the majority of legislatures. In short, in Raich, 6 of 9 justices exercised judicial restraint in deferring to the democratic will of Congress when it came to enforcing the scope of Congress's power under the Commerce and Necessary and Proper clauses. But 3 justices were prepared to draw a line at federal power to prevent citizens from producing and consuming a good on their own property, leaving the regulation of such activities to the states. So in Raich, 6 justices hewed to the Democratic Constitution, while 3 were prepared to enforce the text of the Republican Constitution. Now, the same divide over the proper role of judges in enforcing our Republican Constitution arose 10 years later in the Obamacare case. But by then, the numbers had moved in a Republican direction. There, as in Raich, the 4 more progressive justices were monolithic in their deference to Congress's claim of power to require citizens to do business with a private company. But now, 4 conservative justices, including both Scalia and Kennedy, stood forthrightly in favor of the Republican Constitution's limits on federal power. As we know, however, the 5th swing vote was by Chief Justice Roberts. As I explain in the book, and I tell the story of the Obamacare case, in which Todd Gaziano, who's sitting in the second row, plays a prominent role in the first chapter of the book, Chief Justice Roberts affirmed the Republican limits on the scope of federal power by holding, this is Chief Justice Roberts holding, that the individual purchase mandates were indeed beyond Congress's power under the Commerce and the Necessary and Proper clauses. On the other hand, he then invoked the Democratic Constitution's conception of judicial restraint, adopting what he called a saving construction that turned the individual insurance requirement into an option to buy insurance or pay a modest, non-coercive tax. As he put it, quote, granting the act the full measure of deference owed to federal statutes, it can be so read. And he then defended this move by insisting that, quote, it is not our job to protect the people from the consequences of their political choices, unquote. Now, perhaps he expected this split-the-baby approach to be received by conservatives with equanimity. But it wasn't. Many on the right were outraged by what they believed because they believed that it was the job of the Supreme Court to hold Congress to its enumerated powers and thereby protect the liberties of we the people, even from a bare majority of Congress who enacted Obamacare. In this way, the Obamacare decision was a political inflection point in how conservatives conceive of the role of judges. Ever since the rise of modern conservatism, conservatives have been conflicted. On the one hand, unlike the left, they are committed to following the original meaning of the Constitution. But on the other hand, many have long professed their belief in the doctrine of judicial restraint. Yet ironically, as I explain in the book, the doctrine of judicial deference to the will of legislatures was promoted by political progressives, precisely to free Congress and the states from the constraints on their legislative power that were in our Republican Constitution. As a result of Chief Justice Roberts upholding Obamacare in the name of judicial deference, the trend of opinion among conservatives have moved sharply from judicial conservatism and restraint towards what is best called constitutional conservatism, which favors judges enforcing the original meaning of the text, even if it means invalidating a popularly enacted law. With the judicial philosophy of the court now evenly divided, the next appointment will be crucial. For years, Democratic presidents have been adept at selecting justices who adhere without fail to the democratic Constitution. In contrast, the record of Republican presidents has been deeply disappointing. Appreciating the differences between the Democratic and Republican constitutions helps reveal why this has happened. By selecting judges and justices for their commitment to judicial restraint and deference to the majoritarian branches, Republicans have actually been nominating and confirming jurists who adhere to the Democratic Constitution in practice, at least when the chips are down. No matter how much conservative justices might profess a commitment to follow the text of the Constitution, as Chief Justice Roberts did when he agreed with us that an insurance mandate was unconstitutional, they are always inclined to refuse to enforce the constitutional text against the Congress or the President, as Chief Justice Roberts did when he turned around and adopted what he called a saving construction that changed the meaning of the statute so he could uphold it. And it is standard operating procedure for Republican-appointed justices, in the name of stare decisis, to adhere to post-New Deal Supreme Court precedents that have overridden the text of our Republican Constitution. Since Democrats will never nominate a full-blown adherence to the Republican Constitution, restoring our constitutional republic will require a Republican president who will. A Republican president who will seek out judges and justices who appreciate the Declaration's affirmation that first come the inalienable rights of we the people as individuals, and only then comes government as their servant. And justices who realize that the democratic will of the majority is not the solution to the problem of constitutional legitimacy, but instead that the majoritarianism of democracy is the very problem a Republican form of government is needed to solve. In short, now more than ever, we need a president who will appoint judges and justices who understand that only a Republican Constitution, like ours, can, if followed, secure the liberty and sovereignty of we the people, each and every one. Thanks.